I've always learned to teach my information so that a child can understand it. I do believe that we should be taught and teaching our children the basics of law, the basics of contract, because it is contract somewhere that brought you into the courts or will bring you into the courts or will want you to go into the courts and try to defend something that you're about to lose, have lost, or maybe even want to gain. So with that, I'm going to go back to the Jurisdictionary program, and I'm actually going to lay out some basics. So whether you're fighting a foreclosure or anything, you need to have some basic ideas. And I'm going to try and get more complex based on the building blocks that I give you. So I'm using Jurisdictionary. If you order their homesteading course, this is actually a little bit of a printout of one of the booklets. And Jurisdictionaries, so that he breaks it down very simply. And this was one of his little booklets that calls How to Be Heard in the Court. And the title says, Learning How to Be Heard, Learn How to Make Your Opponents Answer Truthfully in Court. The power is yours. And so what we're talking about is if we get enough people who understand the procedures and the system to be heard in the court about the abuse of the non-judicial foreclosure or the unlawful detainer process, you have to understand how to present it in the courts. And then when the judges aren't giving you the orders that they should give you, what do we do next? What do we do next is going to be a whole other series of courses, and that's where if you get enough people to know what these judges are doing, because it all comes down to their pocketbook. If it starts to challenge their livelihood, they're going to do something different. Dr. Graves starts out with theory of the case. Every case should have a theory. So what we're saying is, no matter what you're dealing with, if you've already lost your home, if you're currently facing a foreclosure, or if your home is upside down in value and you're not sure what to do with it, you should have a theory. You should have a plan and a goal before you even enter into it. Every case should have a theory. The plaintiff's case has one theory. The defendant's case has another. Make certain you understand your theory of a case and make the other side tell you its theory on the record. Do not omit to do this. Many times a case can be won by poking holes in the other side's theory, or if it can be shown that facts simply cannot support the other side's theory, you win. Or if the law cited by the other side doesn't fit the theory they say they are operating from, they lose. If a case theory is not supported by the facts and the law, the case is unwinnable. So that's what we're going to do in this learningthelaw.info program and Stopping Foreclosure Insanity. We start to teach you how to gather your facts, how to understand what the laws are so that you can bring your case so the court must rule in your favor, and how to manage your judge and the other side so that they don't skip over and have the facts hidden. And that's really the name of the game. I want to give create up on the whiteboard a simple little, here it is. In Dr. Graves' Jurisdictionary program, this is the basic, bigger picture of what you're doing with your case. Is you're going to bring a complaint, and in that complaint, you're going to have your facts. You're going to, before you even get to the facts, you have to establish the jurisdiction that gives the court power to hear your facts, your claims, your demands, and the order that you're wanting. What do you want? I want the mortgage found void. I want an adjustment because of all of the violations. I want the fraud to show that not only was there no contract, but here's my damages from it. And not only do I want my actual damages, I want punitive damages so they don't do this anywhere else. That is the basics of our system. So you've got your complaint, and how it moves to the court is done through motions. So nothing moves to the court until you file the complaint and you bring a motion. And the motion is to get to where the other side files their answer. And after they file the answer, we go into a discovery process. And then from there, it goes to the trial, which is going to get you the order if you followed your procedure. Charles, I don't think the average person understands when we talk about filing a quiet title action unless they see a visual, a complaint. Why does the court have jurisdiction? What are the facts? What is fact? What is hearsay? And as I started working with some of the students that have been following, just the idea of what hearsay and facts are, people don't understand. They don't understand how to state a fact, so it can't be turned into hearsay. They don't understand how a fact is not your opinion, and what firsthand knowledge is to establish the fact, both on your side or on the other side. When an attorney starts saying something, and that attorney cannot be saying things because it's hearsay. He doesn't have firsthand knowledge, and how you must object to his statement so it doesn't go into the record and become fact that can be used against you. So, complaint, nothing moves through the court to get you to a trial except through a motion. So if a motion is filed against you, it is to do something. That's how you move your facts over to discovery, to break down what is the truth and what is not truth to win your cause of action, your claims. I entered into a contract, but the contract is void because of this. I signed a note, but because of this, and this, based on these laws. So that's the general idea of what we're talking about doing. Then I'm going to add another level, and that other level, and you'll see in Jurisdictionary's program, he has causes of actions, affirmative defenses. The purpose of learning the law and the stop the foreclosure insanity is to now focus on all the different processes that you can bring to keep your house, to get your house back, or to get credit for money that was taken from you that was in violation of certain codes, laws, rules.